Tonight, with immigration arrests like these playing out across the country, a federal judge now says the Trump administration is crossing a line with its mass deportations. After those controversial removal flights to El Salvador last month, Judge James Boasberg slamming the government for failing to comply with his court order to temporarily halt the planes, writing, "Probable cause exists to find the government in criminal contempt."
The idea that one branch of government would ignore the orders of another is something we haven't seen in our nation's history.
The judge writing, "The Constitution does not tolerate willful disobedience of judicial orders," adding that disobedience would make a solemn mockery of the Constitution itself. The White House says it will appeal. A separate legal case involves one of those deportees, Abrego Garcia, the man the Justice Department initially acknowledged was mistakenly sent to El Salvador.
What's up, people? Welcome to Dr. John Podcast. So what just happened, guys? Judge James Boasberg has filed criminal contempt charges directly and personally against Donald Trump. Not civil penalties, not stern warnings. Criminal charges, carrying up to 18 months in prison. The US Marshals Service is reportedly being prepared for enforcement. The machinery of criminal justice has the sitting president as its target.
The Supreme Court ruled the Trump administration should facilitate Abrego Garcia's return to the U.S. But today, after days of requests, the administration released a document from 2019 stating how an informant allegedly identified Abrego Garcia as a member of the violent gang MS-13, even giving his rank and nickname.
When Abrego Garcia was originally arrested, he was wearing a sweatshirt with rolls of money covering the ears, mouth, and eyes of presidents on various currency denominations. This is a known MS-13 gang symbol.
Abrego Garcia's family denies he's a gang member, and he's never been criminally convicted. Democratic Senator Chris Van Hollen of Maryland went to El Salvador today to push for Abrego Garcia's release, but was denied a meeting with him.
And the potential image of a commander-in-chief being taken into physical custody changes the entire architecture of American governance. The backstory that got us to this precipice is a damning chronicle of repeated defiance that even the Chief Justice of the Supreme Court has refused to sanitize. Chief Justice John Roberts examined the landscape of this crisis and issued a statement that will live in legal textbooks.
This is about due process. This is about not letting people be just whisked off the street, which the Trump administration admits was done in error.
Late today, the White House highlighting the story of Patty Morin, whose daughter Rachel was killed by an undocumented immigrant.
These are the kind of criminals President Trump wants to remove from our country.
The Trump administration is promising deportations will ramp up. Outside Boston, the woman inside this car says ICE officers used a hammer to break a window in order to drag out her husband, an undocumented immigrant who has no criminal record. This surveillance video shows plainclothes officers tackling a Venezuelan man as he arrives in a New Hampshire courthouse, knocking over another man in the process.
Hey, excuse me.
Outrage over immigration now spilling into contentious town halls, including one held by Chuck Grassley, the most powerful senator on the Judiciary Committee.
Are you going to bring that guy back from El Salvador? Yeah. Why not?
Forever, Roberts identified a deeply entrenched pattern of executive defiance. He noted specifically that the president keeps violating court orders with a flagrancy that treats judicial decrees as optional suggestions. When Trump sought an emergency intervention from the highest court in the land to shield him from the consequences of his actions, Roberts refused to grant him that shield. That refusal is monumental.
Well, because that's not a power of Congress.
Supreme Court said to bring him back.
While in Georgia, police tasered two protesters at an event held by Congresswoman Marjorie Taylor Greene.
Bye. Just like that illegal alien. Bye.
All right, Gabe joins us now live. Gabe, let's go back to that man deported to El Salvador. I know you have new reporting tonight on his past.
Yes, Tom. In 2021, a protection order was issued against him in a domestic violence case. The case was closed when his wife did not show up for court. As for the gang allegations, his attorneys have repeatedly questioned the credibility of that confidential informant. Tom.
All right, Gabe, we thank you for that. We want to stay on this breaking news and all the legal developments. So how would a judge put the Trump administration in contempt of court? Laura Jarrett joins us now. So, Laura, what are the realistic scenarios?
This is an inflection point, Tom. The judge today essentially saying he is giving the Justice Department one last chance to comply with his original order. Find those people he says were wrongly put on planes last month. But if the administration does not comply, then the judge plans to escalate this further and figure out who's to blame. The final step here would be referring this matter for criminal prosecution by the DOJ. But what if DOJ won't prosecute? Well, the judge could appoint an outsider, but that person still answers to the Justice Department, all illustrating just how quickly this could potentially turn into a remarkable confrontation.
And still so many steps. All right.
The Supreme Court, the ultimate arbiter of constitutional meaning, looked at the criminal liability crystallizing around Trump and decided not to deploy its formidable power to stop it. The institution said no to protecting a president whose signature behavior is ignoring the rule of law. The epicenter of this earthquake is something called Operation Metro Surge. This was a directive personally driven by Trump that ordered the Department of Homeland Security to bulldoze straight through federal court orders specifically designed to halt deportations. Judges issued legally binding commands to stop the raids, pointing to glaring constitutional violations and the absence of due process. Trump's response to those orders was not to appeal them through the proper channels or to seek a narrow carve-out. It was to order his agencies to continue the raids anyway. He commanded warrantless deportations, even as judges were screaming from the bench that these actions were illegal. The human cost of that criminal defiance is not measured in political points or poll numbers. It is measured in body bags. 3 migrants died in these unlawful operations. 3 human beings lost their lives because the President of the United States decided that his policy preferences outweighed the constitutional authority of the courts. Those 3 deaths transformed the legal calculus from procedural contempt into something far darker, a terrain of potential manslaughter and murder considerations that prosecutors cannot ethically ignore. Trump is now facing jail time not just for ignoring judges, but for the lethal outcome of that ignorance. The evidentiary foundation that Prosecutor Boasberg is building rests heavily on the bond memos, a set of internal documents that are utterly devastating to any defense of plausible deniability. These records show that Trump issued direct override orders. They reveal that Trump specifically instructed leadership at DHS to ignore the courts entirely. The paper trail confirms this was not an accident born of administrative negligence or a misunderstanding of legal boundaries. This was meticulous, deliberate, knowing defiance orchestrated from the Oval Office. Trump ordered people to violate the law. Trump ordered government servants to ignore the judicial branch. And that specific species of intentionality is exactly what the criminal contempt statute is designed to punish. The Department of Justice's own internal accounting further damns the operation, having documented 47 unlawful deportations. 47 individuals were ripped from the country in direct violation of federal court orders. 47 times the constitutional rights of people were shredded. And as we now know, 3 of those cases ended fatally. Trump's reaction to this existential legal threat has been nothing short of volcanic. He has declared that they will never take him alive, framing himself as the victim of a deep state coup. He has called the judge a fake and the courts illegitimate, whipping his supporters into a frenzy while insisting he will physically resist any attempt at arrest. But the theatrical fury of his pronouncements crashes against an immovable wall. Roberts already said no. The Supreme Court already cleared the runway. The defiance pouring out of Mar-a-Lago or the White House simply doesn't matter anymore because the law has locked onto its target. The political ecosystem surrounding Trump is not absorbing this shock. It is shattering apart. The Republican Party, already staggering from brutal internal schisms over war funding votes and the explosive contents of the recently released Epstein documents, is scrambling to put as much distance between themselves and the president as humanly possible. The same senators who once marched in lockstep are now leaking to reporters that they had no knowledge of the criminality embedded in Operation Metro Surge. They are painting the president as a lone actor who dragged the country to the brink of constitutional collapse without their consent. They are abandoning him to face this catastrophe alone, signaling that the political cost of defending criminal contempt is simply too high to bear. The White House complex is in a state of absolute panic. Counsel's office lawyers are pulling all-nighters trying to find an exit hatch that simply does not exist. Senior staff members are paralyzed, oscillating between writing resignation letters and crafting contingency plans for a government that has a president in a holding cell. No one has a playbook for this. The entire federal apparatus is wobbling under the weight of Trump's lawlessness, and the chaos is seeping into every department. The role of the Department of Justice in this saga adds another layer of institutional rot. The DOJ was deeply complicit because the leadership followed Trump's orders to violate the very court orders they are sworn to uphold. Career prosecutors, many of whom dedicated their lives to the impartial administration of justice, were forced into a corner by political appointees who valued loyalty over legality. Now, those career prosecutors are being called to testify. They will have to sit in a witness box and explain under oath why they participated in a scheme to ignore judicial commands. The Justice Department itself is now implicated in contempt of court, revealing the extent to which Trump's influence has corrupted the machinery of law enforcement. The Supreme Court's refusal to intercede remains the pivot point of the entire conflict. Roberts had the raw judicial power to issue a stay that would have paused the prosecution and given Trump a temporary shield. He chose not to. By invoking the concept of a pattern of executive defiance, Roberts placed a judicial seal on the narrative that Trump is a serial lawbreaker. This implies that the court has been watching, that warnings were given in prior rulings, and that Trump's decision to persist was a conscious choice to challenge the judiciary's supremacy. Roberts essentially told the nation that the Supreme Court is not a political body designed to rescue a president from the natural repercussions of his own contempt. The immediate timeline is staggering, and it should terrify anyone who understands the logistical complexity of arresting a president. A hearing is scheduled for tomorrow, but the arrest could come hours before that. The President of the United States could be in custody when the sun rises. He could be eating breakfast in a federal detention facility. This is not a sluggish political process that takes months to unfold. This is a high-speed judicial freight train barreling toward a constitutional conclusion, and no signal lever appears to be working to slow it down. To fully internalize the magnitude of this breaking point, we must dissect Operation Metro Surge and understand why it is the final straw that breaks the back of executive immunity. Trump authorized a blitzkrieg of mass deportation raids that were structurally aggressive and legally warrantless. These raids were cast with a net designed to ensnare immigrants irrespective of their documentation status or legal protections. Federal judges, recognizing the raw tyranny of disappearing people without judicial review, issued orders that were clear, specific, and absolute. They commanded the administration to stop the raids. They required the government to halt the physical removal of bodies from American soil. The command was not ambiguous. Trump's response was to ignore the ink on those orders and verbally instruct DHS to maintain operational momentum. The 3 deaths are the moral core of this story. Real families were destroyed. Children lost parents. Spouses lost their partners. The abstract concept of defiance became concrete homicide when people died as a direct result of a presidential order that violated a court injunction. Boasberg's escalation to criminal charges reflects the exhaustion of every other remedy. The judge tried standard orders. He threatened civil contempt. He gave the executive branch multiple off-ramps to comply and save face. Trump swerved into every single barricade, accelerating his defiance at every turn. When civil penalties fail to stop a lawless actor, criminal force becomes the only tool left in the box. Boasberg decided it was time to open that box. The figure of Attorney General Bondi stands as a cautionary tale of complicity. Bondi was the chief law enforcement officer of the land, vested with the responsibility of ensuring the department followed court orders. Instead, she mirrored Trump's lawlessness. She instructed prosecutors to bypass judicial rulings. She enabled DHS to continue its illegal operations. Her complicity and contempt was so complete that she eventually became a liability, and when she finally wavered, refusing to sink further into the abyss of illegality, Trump fired her and replaced her with someone more pliable. The Supreme Court's decision not to intervene was a signal that the judiciary's patience for this kind of weaponized bureaucracy has evaporated. Roberts understood that this confrontation was no longer about a specific policy disagreement, but but about the survival of judicial review itself. The refusal was an affirmation that the courts are the final word on constitutional meaning, and that the president, regardless of his bluster, must face the music. The career prosecutors dragged into this nightmare are not loyalists. They are institutionalists. They never wanted to be in contempt of court. They swore oaths to the Constitution, not to a personality. Trump put them in an impossible ethical vice, ordering them to violate the very laws they were hired to enforce. Now they are witnesses to a crime, and their testimony will be used to demonstrate that the criminal intent flowed directly from the top of the food chain. The timing of this criminal vortex aligns with a pre-existing political cataclysm. Trump was already bleeding support due to the GOP's rebellion over foreign war funding allocations. His base was fracturing, independents were fleeing in droves, and the dark cloud of Epstein-related disclosures was already eroding the myth of his invincibility. Into that weakened state drops a criminal indictment with prison time attached. It is a kill shot to his political viability. The constitutional question now being tested in real time is unprecedented in American history. Can a sitting president be arrested? Can he be physically confined? What happens to the nuclear chain of command when the man with the football is behind bars? The honest answer is that nobody knows the precise procedural sequence because it has never happened. The framers never imagined a president so contemptuous of the law that federal marshals would need to unlock the resolute desk to cuff him. The courts are essentially building the procedural plane while flying it. The core ideological battle is between the cult of presidential power and the supremacy of the rule of law. Trump has spent years arguing that his authority is essentially limitless, that judges cannot touch him, and that his position elevates him above the mundane legal constraints that bind ordinary citizens. But Boasberg's gavel and Roberts' refusal have shattered that illusion. They are declaring that the Oval Office is not a sanctuary for criminality, and they are backing that assertion with the physical enforcement power of the state. When we look forward to map the fallout, the landscape is one of absolute disarray. The immediate reality is that Trump might be incarcerated. The symbolic weight of a president in a prison jumpsuit will change the global perception of American democracy. The betting markets on impeachment have spiked to 48%, indicating that the legislative branch is moments away from being forced to act. Congress cannot ignore a criminal president sitting in a detention block. The Republican Party faces an existential choice that will define its future. They can stand with Trump attempting to physically shield him from arrest and thereby endorsing criminal contempt, a position that would eviscerate them in suburban districts across the country. Or they can distance themselves, treating this as a personal criminal matter between Trump and the courts, effectively cutting his political throat to save their own necks. Every signal from the caucus suggests they will run for safety. The defections we have already witnessed are simply a preview of the stampede to come. The midterm projections reflect this doom, displaying potential losses of 40 seats or more. That is not a red wave. That is a tidal surge of voter disgust, washing the party out of power. The 70% of independent voters demanding accountability represent a supermajority of the persuadable electorate, and they have zero tolerance for contempt of court. The Senate's role becomes paramount if arrest turns into conviction. The upper chamber would have to prepare for a trial, and the numbers suggest a potentially cataclysmic outcome. At least 17 Senate Republicans might join Democrats to vote for conviction and removal, a threshold that would not only end a presidency, but reset the ideological alignment of the chamber. The 25th Amendment is also being actively discussed in cabinet-adjacent circles. If Trump is deemed incapacitated by his own erratic and self-destructive refusal to accept the rule of law, the mechanisms for his removal via the cabinet are constitutionally available, even if they are politically radioactive. The House of Representatives, the origin point of impeachment, will have no legislative cover to avoid drafting articles. A criminally indicted president who is facing imminent jail time over the deaths of civilians is the textbook definition of high crimes and misdemeanors. Speaker of the House will find it impossible to suppress the procedural motions to begin the process. The judicial branch will continue to tighten the screws. Judge Boasberg is clearly not playing any games, and if Trump attempts to physically resist the marshals, The courts will escalate their enforcement measures because the judiciary's credibility is now staked on this single confrontation. If a judge cannot enforce an order against the executive, the separation of powers ceases to exist. The military is also a silent but decisive observer in this drama. If Trump attempts to invoke the Insurrection Act or deploy forces to obstruct his own arrest, the general staff will face an immediate moral crisis. Their oath binds them to the Constitution, not to an individual. The Constitution explicitly mandates that judicial orders be respected. The military brass will almost certainly refuse to deploy troops to protect a criminal from the courts, marking the definitive end of any authoritarian aspirations Trump might harbor. The White House is not functioning as a policy shop anymore. It is a crisis management bunker. The paralysis in decision-making is absolute because the hierarchical chain of command is psychologically broken. The vice president's team is quietly consulting constitutional scholars about succession protocols, and the agencies are essentially running on autopilot, waiting for the dust to settle. The international community is viewing this spectacle through a dual lens of horror and respect. The arrest of a sitting president sounds like the stuff of a failed state, but the peaceful enforcement of a judicial warrant against the most powerful executive on earth also demonstrates a profound institutional strength. It proves that America is not a personality cult, but a mechanism of laws. That moral authority, hard-won through centuries, is being reinforced even as the political scene appears chaotic. The narrative that will settle into the history books is one of vindication for the legislators who broke early. Those Republicans who voted to constrain Trump's war powers will be seen as the canaries in the coal mine who correctly identified the slide toward authoritarian criminality. The career prosecutors who were forced to follow illegal orders will be seen as victims of a corrupted chain of command, not perpetrators. The victims of the Metro Surge deportations, those who survived and the families of those who did not, will find some measure of justice in knowing that the system ultimately reacted with lethal force against the man who broke it. The cascade of legal arguments Trump's lawyers will attempt to deploy, ranging from absolute presidential immunity to claims of executive privilege, have already been functionally shredded. Boasberg's filing explicitly acknowledges that the president knowingly violated court orders, and Roberts' statement of a pattern undercuts any claim that this was a one-off misunderstanding. The trial for criminal contempt is procedurally straightforward because the evidence of intent is so starkly obvious. The bond memos and the DHS operational logs provide a real-time documentary of intent. A conviction is statistically inevitable, and the sentencing will be calibrated not just to punish, but to send a chilling signal to any future executive who thinks courts can be ignored. The Republican base, a demographic that has endured repeated psychological shocks defending the indefensible, is facing a shattering moment. The image of their leader in an orange jumpsuit is not one that can be spun away by Fox News prime time. It is a visceral, degrading reality that breaks the messianic illusion. The historians analyzing this period will mark this verdict as the moment the judicial branch reclaimed its Article III supremacy from an executive that had attempted to swallow the government whole. The ultimate philosophical question hanging in the air is whether this country is governed by the whims of powerful men or the cold text of established law. Judge James Boasberg and Chief Justice John Roberts have answered that question with startling force. America is a nation of laws, and those laws apply with relentless, grinding absolute precision, even to the person sitting in the Oval Office. The future of presidential constraint is being mapped as we speak, and it indicates that the era of unchecked personal rule has been slammed shut by a judicial branch that refused to blink. The executive branch will adapt to the temporary gap in leadership because the vice presidency and the statutory line of succession exist precisely for moments of constitutional fracture. The government will survive Trump's physical removal from office far more easily than it survived his corrupt presence within it. The election cycle will be dominated by the footage of this arrest, and the voter backlash against authoritarianism will reshape the electoral map. Things are about to accelerate beyond anything we have ever witnessed, and the conclusion is as grim for Trump as it is hopeful for the Republic. The rule of law has prevailed, the courts have spoken, and the machinery of justice is in motion, and nothing can stop it.